today, I was looking through the forms, through the Northwest MLS and Express forms, and noticed a section of forms that we really don't talk about a whole lot. And there is a lot of value in the forms that are in this section. The section I'm talking about is the notices. So in this forms class today, I'm going to be discussing why we should use these notices when possible. We'll talk about the Statute of Frauds, the fact that we have a standard of care that we need to uphold as realtors. We'll talk about official ways to respond to contingencies. These forms also make easy documentation. And when you have a notice, you're talking about a one-sided response. So there's no need to have a mutual accepted response. Another reason we can use these forms is it does help enforce an obligation. And if we need to, these are also one-sided terminations. So let's talk about the Statute of Frauds. In real estate, everything needs to be done in writing. And typically what we think about when we think about things done in writing is, of course, an offer. But everything else that has to do with real estate also includes the same Statute of Frauds. We have done emails back and forth. We have done, contract forms. That all is included with this. And to have these notices in writing helps us with another one of our obligations, which is the standard of care that we are supposed to be held to. So the 90 series is the forms that I'm going to talk about. I'm going to vaguely touch on almost all of them, mainly because I wanted to bring light some of these notices that we have to our disposal that are not being used at the moment. So the first one is the blank notice. We have an obligation as a seller to deliver the FERPTA to escrow. And there has been this ongoing conversation since this started, this 10-day response to how the FERPTA works started. How do we prove that we've given it to escrow? Escrow does not give us a receipt. The only thing we can do is rely on them saying, yes, they received it. So a blank notice would be an appropriate place to write in FERPTA delivered to escrow, attach the FERPTA to this form, and then send it on its way to all parties. Another reason you may consider using this blank notice is if you think about a 22Q, a pending sale. We don't really have subsequent forms that respond to what happens if that sale falls through. In that situation, we do have to give notice. Now, in the past, we've probably just given notice by sending an email and saying, hey, by the way, sale fell through. Well, a Form 90 is also another appropriate way to document that communication. It also helps keep it in AuthentiSign. We have signatures of the parties that we are representing, and it shows that they have actually seen what's being forwarded on. So another thing, sellers' home instructions. Think about when your buyer is moving into a home and there's maybe a complicated security system or something else that has no part of the contract. There's nothing in the contract that says, hey, I need you to give me directions on how to use these things. One way we can deliver that information is by putting it in a notice. And then think about using notices for the delivery of any documents that are outside of the contingencies. So if you have something like maybe receipts for work that gets done on the home inspection or any other document you want to officially deliver, you can go ahead and put it into this Form 90 blank notice. So kind of going down the list of the notices that are available to us, we have the Form 17. The buyer has the opportunity to review the Form 17, but how do we actually terminate based on that? The Form 90A is actually a rescission for Form 17. So Form 17 is the way that you are choosing to terminate the contract. Make sure that you do search in the 90 series and find this to use for that termination. We also have the obligation when we put a contract together to deposit earnest money. And in doing so, we all know the rules. If the earnest money is not deposited by the date promised at 9 p.m., then the seller does have the right to terminate that contract. We talked about this a couple times ago in a different forms class. But should that seller want to exercise that right, the termination form they would use, because earnest money was not delivered on time, is actually in the notices. It's 90B. Make sure if you use this notice, you are waiting the full time that the earnest money is supposed to be deposited, and it is after 9 p.m. because all of our deadlines still end at 9 p.m. So if a sale fails to close, I'm sure many of us have reached the closing date and something has gone on in that contract where it's not going to close. And maybe you're in a situation where buyer doesn't want to sign an extension or seller doesn't want to sign an extension. If our sales are failing to close, then we have these two notices we can give that just basically also instructs escrow that these sales have failed to close. It does also give demands for earnest money. So it's essentially like a form 50 almost, where we want to give escrow the instruction that the sale has failed. We are going to be demanding earnest money. If there is earnest money in escrow, though, I would also suggest using the form 50 to allocate who gets that earnest money, because there are a lot of different reasons that a sale may not make it. If you have evidence of funds, now I've not really used this one personally, but if you have evidence of funds that is not being provided and your seller just feels really uncomfortable with the way this transaction is going, by not providing those proof of funds, the seller has the right to terminate. So where do we look for that right to terminate? Well, we look in 90s. This is the 90EF. All of the numbers are similar in number and letter. Like, so we have the 22EF for evidence of funds. This is the 90EF for the notice of the 22EF. You can kind of just use that as a gauge. They're not always accurate like that, but seller does have the right to terminate if earnest money funds are not deposited in time. And the way the termination happens is the 90EF. So remember, like I said in the beginning, we are required to deliver the FERPTA to escrow. Consider delivering the FERPTA with the Form 90 and CC all the parties involved. But if the FERPTA is not delivered, we know it's due within 10 days of mutual acceptance. What happens at the 10th day? We need to be tracking communication of what happens if FERPTA is not delivered. Think of this as importantly as the inspection response, right? If we see the FERPTA has not been delivered, the buyer does have a right to terminate. So we want to communicate that to our buyers. This is just a notice, like I said, but this should follow a FERPTA not being delivered on time. And as far as the Statute of Frauds goes, this is perfect communication on what that buyer's choice is once they know the FERPTA has not been delivered. Remember the consequences too. If the FERPTA is not delivered, the buyer could be stuck paying taxes. If in fact the seller is not a citizen and doesn't disclose it. The 90I is a termination that you'll use for financing not being available. Keep in mind, any of these terminations you use still have to follow all the guidelines on what it takes to get out on those contingencies. So if you're using this 90I for financing termination, you're also going to need to attach a letter from the lender. And if you look at 22A, it will show you all the things that need to be in the letter in order to use this. I stuck this feasibility one in there because, we have the 90K, the 90L, the things that are for, specifically for like contingent sales. I left those out on purpose because the contingency and 22B actually names those forms as the ones to use next. I didn't think there would be any confusion on this, but we have a contingency of feasibility. Now, in the feasibility contingency, if there is no response given, a lot of times by the deadline, there will be an action already in place by the form. If you want to respond prior to that deadline, or if you want to respond with something other than what defaults at the deadline, the form you want to use is a 90P. And this one just gives the option of either termination or satisfaction. So again, responding to the feasibility, look in the 90s. When dealing with condominiums and viewing the resale certificate, the buyer does have the option to review the resale certificate and either find it acceptable or not. And if a termination is needing to be done based on their review of that resale certificate, you'll want to search in the 90s for 90R. That is termination for an unacceptable resale certificate. Now, it's possible that if you're still in an inspection contingency, maybe you want to use 35R as your cleanest way out. But these are all forms available to us because everything in here does have a contingency with an action that can be taken. And the actions are one-sided actions. So if you have something that your buyer can get out on that is solely their decision, I would choose that over any sort of mutually accepted rescission anytime. Now, this one is actually one of my favorites, and I use this one quite frequently myself. It's the notice that the title commitment is available. So when we get the title report, we still have to deliver it to that other party. So when we deliver it, we usually email the firm, email brokerment, email, and we're attaching these big lump, attachments into this. This right here is the seller's notice, and what happens here is we have the seller sign that they are delivering the title report. They can deliver it as an attachment. They can deliver it to the office in person. It doesn't really matter. It just documents how it's delivered. And by having them authentic sign it, it puts a date in here. So if you have a title contingency, it just helps kind of fall back on when that was given and when that timeline starts. It also has a place for you to go ahead and write your order number for the title report. I actually really like using this delivery notice. All right, 90T. This is the contingency notice if the title does not meet something that the buyer needs. It's a pretty difficult contingency to just get out on. It's not your typical get out of jail free contingency, but because the title contingency is something that exists, if the buyer plans on terminating for a reason that is acceptable from that contingency, the response for that is similar again to the inspection response. You're going to look at Form 90T. And what happens is it kind of gives this sort of play-by-play on buyer's decision, seller's response, buyer's response. It is a great way to document this conversation. Again, by using these forms, we are showing that we are competent in our selection of forms, that we're using everything that's available to us. And as far as the statute of frauds go, we have proof of communication from all of these things. The 90W is based on the Homeowners Association review. And I pulled this one up because it's a really common contingency that we see in the optional clauses. So if for some reason you have a client who has a contingency in 22D with an HOA review period, and they have decided that this is just not acceptable. The response form for this is a 90W. And as we get towards the end of the alphabet, the 90X is termination for the well addendum. What I wanted to do mainly on this one is caution that this is not a termination because of the water quality or water quantity contingencies. Those have their own responses. Those ones would use the 22RN, just like the inspection response. It has a communication back and forth, it has timelines, and it has buyer decision. But this part, the 90X, should be used for paragraph 4 of the well addendum, where it has it obligates the seller to deliver documentation on the well, and it's about the review of those documents. Again, if you have contingencies on your well, you're going to want to make sure you respond with a different form. This one is just for information that is provided to you. $90Y is for a septic addendum termination. This is more get out of jail free type termination than most of the other ones. The only thing a septic review says is that it's, at buyer's discretion upon seeing the report. So if you see the septic report and buyer decides that this just is not an acceptable thing for them to buy, the way that you terminate the contract based on the septic addendum is by searching form 90Y. Again, this does not need to be proven for this one. It mainly just needs to be buyer's discretion. And as always, with all of these terminations and notices, make sure that you're keeping an eye on your timelines. 90Z is a notice of information verification termination. That's a lot of Asian. This one needs to be based on materially inaccurate information. So one thing we can do as listing agents is to make sure that when we do our listing input, we are filling out all the required boxes, we are doing it accurately, and hopefully avoiding this opportunity to use this contingency for any buyer. It is a negotiable part of the contract, so sometimes this is taken down to 0 days, but nonetheless, it is still a contingency in that contract, and it is still a way for a buyer to possibly get out if they find something materially inaccurate. Again, 90Z is where you'll find that one. Remember that our standard of care is put on a pedestal. As realtors, we're held to the same standard of care as a lawyer. We're required to use the forms available to us and to use them in a way that is competent. These forms are here for us to use and document responses in a professional way. So consider the forms when you're responding to contingencies that do require notice from a buyer to a seller. There are a lot of forms in the 90s that cover a lot of the ways we need to be responding. Thank you very much for listening.